Alrighty, so I put it out to the group last week what people wanted to hear about, and Nigel was the one that come back and wanted to hear basically about the property structures that you can have when purchasing residential property, or it even applies for like leases. If you purchase or you're entering into a lease with more than one party, you'll still have to, explain what the structure of that is. So let's begin. Basically that's what I'm going to go through today. So there's a few different options that you can purchase property in, and we'll go through them in depth a little bit to teach you about what your options are when you're looking to enter into the property transaction for your residential home or a lease. So you've got three options when purchasing with two or more people or entities, and those are you could be a joint tenant, a tenant in common, or as trustee of the property. So it's always important to make the decision from the outset and make sure it's the right one. We can give you advice like I'm going to today, just give you a general overview of the different options and what they mean, but it's definitely important that you actually sit down and talk to your financial advisor or your accountant as to what structure is right for you, because what might be right for you is going to be different for someone else that's got in a completely different situation and doing the purchase for different reasons, whether it be investment or just as their principal place of residence. So the first option that you may choose is joint tenant. So basically as a joint tenant, that means that you and the other party, or whether there's three or four, you all own that property jointly. So basically, should one of the parties not survive the others, that party that's deceased, their share will automatically be transferred into the surviving tenant's interest. So basically, there is a form that will get lodged with the titles office, transmission of death, and automatically then the titles office will update the title search, which is basically what shows that you own the property, to allocate that interest to the surviving tenants. So this is a copy of the transfer document. So when it comes time to purchasing the property, I know it's a bit small, but I'll just run you through the main part that I want to talk to you about. You have the option, we as your solicitor will ask you how you want to own the property, and it'll be one of those three options. Once we've got your instructions, we'll draft these transfer documents, which is a Queensland Government form that get lodged with the titles office. And in item number 5, where it's got your transfer details, which might be a bit hard to see, we will put on the right hand side the ownership structure. So in this particular case, they're as joint tenants. So the second option that you've got is as tenants in common. So if you decide to purchase as tenants in common, that means that should one party not survive the other, or maybe there's three parties, so maybe two won't survive, their interest in that property will be allocated to what is listed in their will. So yes, it's definitely highly important that you have that will in place, because upon the death, we will look at the will, see what's written into the will, and whoever's listed as the beneficiaries, or there might be one, might be two, could be three, that interest will then be transferred into their name. Again, there's another form that will be lodged with Titles Office to enact that, but that's the basic process of it. So with tenants in common, you have the option of owning a different percentage. So joint tenants is an equal split, whereas tenants in common may mean that you own 20%, your partner owns 80%. If there's three, it could be an even split, so 1/3 each. It's up to you what you decide with the split and how that's worked out. So this is just a sample of title search. So once the property is registered in your name, this will be what you're able to search, basically pay for a search with the titles office, and this is what is produced. There's no longer the original certificates of title, which I've seen a few of them, but basically they're obsolete now. They don't get issued. It's just an electronic version that we're able to search for online. So up in, you've got the registered owners, which again is a little bit small, but you've got two people that own this property, and their interest on the right hand side, and underneath that in the middle it's got as tenants in common. So this particular one, the first owner has 1/3 interest, whereas the second owner's got 2/3 interest in that property. So should the first owner pass away, their third interest will go to whoever's listed in their will as the beneficiary. Just a quick overview on this property. The easements, encumbrances, you've got 1, 2, 5 listed. So the first one, you'll see that on every single title search. That's just basically reserving rights to, the Crown. So that means, should there be a resumption or something, they've got the right to your land. Second one, there's an easement over this property, which just means there might be underground drainage or something that you can no longer build or dig on that parcel of land. You've got a mortgage, which Ben knows all about. So that's obviously where they assist as a broker. They'll get all the paperwork done to register that mortgage. This one's also got a lease and also a caveat. So for us, we always do a title search check on the day of settlement to make sure there's no caveats, because a caveat will stay on the title with the property, and then you as the buyer are liable for whatever debt that relates to, or we have to basically search. Caveats can be for different things. So the third option is as trustee. So if you're purchasing the property as trustee, then there's obviously a trust involved. So your accountant or your lawyer might be involved in setting up a trust for whatever reason. You might have self-managed super fund where there's a trustee involved in that. And basically we need, as the lawyer, to be able to register as trustee one of three options, which we've got listed up here. So it's either the certified copy of your trustee document, or we can have the original, but mind you, that gets lodged with Titles Office, so we don't recommend that. Or the third option is a Form 20, which is a newer option that they've now allowed us to do, where it's just that we just need to know the details, fill in a form on your behalf, which is called the Form 20. Again, another Queensland Government form. So this is a copy of that. And again, we just fill in the details of the trust on that form, and that gets lodged with the transfer document, which was the previous one we showed you. So as I mentioned before, the issues with having tenants in common are that what happens if someone doesn't have a will and they do pass away. So unfortunately, in that situation, it's a bit more of a process for the family or whoever is trying to deal with their estate once they're no longer here, in trying to basically recoup that property from, it will go to like the public trustee to deal with. It's a state government organisation. So basically they'll be in charge of the estate as the trustee because there was no will to appoint anyone. And that's quite a process. So obviously we do recommend having that will if you are having the property's tenants in common, or even if you're a sole owner of a property. Or in general, everyone should have one, but yeah, definitely so. Family law disputes is another issue where it can arise with basically, having a property jointly, tenants in common and things like that. So when we have, a severance of a relationship and we might want to basically transfer property from two people, so married couple, to one person's going to buy the property out basically. So with that, there's smaller costs involved. If you get a court order, it can mean that you're exempt from paying transfer duty again. However, you still will have to pay like a registration fee with the Titles Office. So, that's not so much of a big deal, like these things happen all the time. But, there obviously are legal fees and registration fees involved in undertaking that. So transfer duty, like I mentioned just before, that's another thing that's payable to actually originally transfer the property into a name. But also if you've made the mistake at the outset and you want to then transfer it at a later point in time. So some of you may remember towards the end of last year I mentioned a client that purchased a $5 million property and they were wanting to purchase that as an entity, which means they're paying about $260,000 in transfer duty at the outset, but then they had the plan to transfer this property into the individual's name, so husband and wife or whoever it might have been in their case. And then that means they're subject to that liability again. It's not like a family law court order where they're exempt. It's going from one entity into two individuals. So they've got to pay double duty. So instead of paying $260,000 to have it in individual names at the outset, they're instead paying $520,000 in stamp duty. Along with that, the price of lodging that Form 1 transfer, that's $17,000 for a $5 million purchase. So that's another expense that they're going to have to pay twice. So that's why it's really important that you do speak to your financial advisors at the outset to make sure that that entity is correct and you're not paying these things, repeatedly. So your other costs that you'll have, like I mentioned, the Titles Office registry, but then also, your legal costs. Like although it doesn't cost a lot for us to do the transfer form up to transfer the name, it still is an expense that you don't want to be paying twice. So basically get it right the first time is what I can say. So that's just basically, a bit of an overview of how the property works and the structure of it in regards to residential, or even, when you're purchasing commercial property or as a lease holder. Thank you.